Welcome to The Print. Black money has often been one of the most hotly discussed and debated political as well as economic issue in India, especially over the past decade or so. Before 2014, as you'd remember, it galvanized a popular civil movement. And after 2014, after the BJP government came into power, one of its primary promises was that it would bring back black money from safe havens abroad. In fact, in 2014, when Prime Minister Narendra Modi announced demonetization of high currency notes, he said that he was doing it primarily to fight black money. So as you can see, if it has been discussed and debated and has been a point of concern, of course there have been several laws and several policies that have tried to deal with this problem, and this is exactly what we'll be talking about in today's episode of Laws of the Land, along with a 2015 law that especially focuses on this issue. Now for this episode, you have me, Apoorva Mandhani, we have with us Bhadra, Sinha, and we have with us Supreme Court lawyer and a qualified CA, Deepak Joshi, with us to discuss this with you. Thank you so much for joining us, Deepak.
Thank you, Deepak, for coming back to the show. This is your second episode with us.
Yeah. Thanks for that.
So, Deepak, before we move on to the 2015 Act, which was specifically brought in to deal the black money menace, we've had acts in the past as well. We've had laws in the past as well. So we would, of course, I think we would be briefly talking about those laws as well. But before we talk about them or move on to them, can you, for the benefit of our viewers, explain how do these laws define black money? How did they define, and how does the current law also define black money?
So it's a very interesting question you've put out. As a subject, black money is known to all, practicality of life. However, under no law till date, this term has been defined. So it's not been defined anywhere, it's not been quantified officially anywhere. What they define it is in reference to the position of your assets or income in the eyes of the government, whether it's been recorded or not recorded, it's been disclosed or not disclosed. So this bright line test is followed. If it remains unrecorded, undisclosed, it's not a money which is legitimately in your account. You failed to disclose it, and hence it is under the radar, under the records, and hence it's black money.
So are you trying to say black money is not typically what we say cash?
It's not restricted to cash.
Okay, it is not restricted to cash. So what kind of laws, has India had in the past to deal with black money?
Those laws are still prevalent, they are current. And in fact, government after government has come up with different laws. As on date, they represent a package of laws which address the problem of black money. Of course, starting primarily with the Income Tax Act. It has many provisions which directly attack the problem of black money, whether in terms of unaccounted cash, undisclosed assets, or undisclosed transactions with residents in India or residents outside India. Now, this is as far as within the country as well as outside the country transactions are concerned. One more law which directly attacks the transactions which are outside the country is FEMA. But it's restricted in its operation to merely regulating the flow of the foreign funds and compliance therewith. There was one more act which was toothless till about 2016-15, which was the Binami Transaction Prohibition Act. It was enacted in 1988 but remained inactive till the better part of 2014-15, and that's when the amendments started taking place. Machinery provisions started being enacted, and assessments started taking place under that particular law. As on date, apart from these laws, there is also another law which is known as PMLA, Prevention of Money Laundering Act, wherein again the focus of the act is to address transactions which may have led to the generation of black money, or the generation of such transactions which are not ordinarily reported to the government agencies. So this is how the governments back in the day and current as well have tried to address the menace of black money.
So Binami Act is the oldest amongst all,
yes,
we can say. So what was the purpose of bringing in the Binami Act in 1980s?
Yes, I go back to your first question, whether black money is only cash.
Okay.
This act addresses that issue. Black money is not only about cash. Black money is also about property which is not purchased in your name but with your funds. There is someone else, a dummy buyer, and you are a Binami buyer. Your name is not on the records of the property. So this is not a disclosed property in your name. So that dealt with non-cash transactions but property related transactions. So that was the limited remit of Benami Property Act.
And why do you think was the need felt to have the law in place?
So this goes back to 1970s. The first committee which was put in place was known as Justice K.N. Vanchu Committee. It recommended an overhaul of the Income Tax Act as such. It also recognized that the tax rates are too high, which is actually promoting diversion of funds and generation of assets and cash, which is not recorded. Thereafter, several amendments were made, first to the Income Tax Act. Thereafter, there was one more parliamentary committee, which is known as Vijay Kelkar Task Force, that recommended for the first time that there has to be an act directly attacking the Benami transactions, which is prevalent in the real estate market as well as the general transactions. So it's been a journey of around 30-40 years. It's not a sudden realization. And whenever each law was enacted, certain loopholes were there in the minds of the legislature, which they tried to overcome with subsequent amendments or a fresh look with a fresh law in place.
Before the next question, for our viewers, from the laws that Deepak mentioned, we have separate episodes on FEMA on which Deepak was here. So I'll add a link to that in the description. We have an episode on PMLA as well that you must watch. I'll add a link to that as well. Now, to the next question, since we're talking about Binami Act right now, you mentioned that there were several amendments that were brought in and that sort of gave tooth probably to the act. Could you tell us a bit about that, please?
So when the initial act was formulated in 1988, everything was delegated to delegated legislation, which was in the form of rules and notifications. Even to the extent of the power of assessment or attachment or the charge of tax was not present in the act. It was only later in time that substantive amendments were made to enable the coverage of the act in tandem with the rules which are framed. The Supreme Court has ruled on the validity of those amendments and the effect of those amendments to past transactions, and has rightly held that these are substantive changes which are made because the coverage of the act is being increased. The charge is being created for the first time on a subject matter of Binami property, and also that the assessment procedures, attachment procedures, etc. are being taken care of for the first time in the law. So if these are substantive changes, they have to apply prospectively, and all the transactions which were sort of under the shadow of doubt before these amendments are not going to be adjudicated in the new law.
Okay. So if we talk about these package of laws, how do these laws individually target black money? Because for now it feels like a very scattered approach up until then. So could you tell us a bit about that maybe?
And another thing I want to understand is that can all the laws be invoked together? Because I think not all provide for criminal prosecution, or do they? Or some must be civil remedies as well. So can all of them be invoked together against a particular entity or individual or a company?
Yes. So I'll answer that question in parts. To a certain extent, there are certain laws which coexist together and they can parallelly be attracted to a particular transaction. For example, there is a foreign income or a foreign transaction. To that, FEMA compliance would apply.
Okay.
And the prosecution under FEMA compliance is both civil as well as criminal. The parameters would differ, of course, from, let's say, an Income Tax Act proceeding.
Okay.
So on that transaction, Income Tax Act will also apply, but for a different purpose.
Okay.
The end would be the same, which is a prosecution and recovery of tax.
Okay.
But the parameters would change. In fact, the defenses available under both the acts would also be different, sometimes contrary to each other. For example, under the Income Tax Act, when we talk about acquisition of assets outside India, till about 2012, there was no need to disclose such assets in your income tax return.
Okay.
But if you've done a transaction abroad, you have to report it under the FEMA law.
Okay.
So once you report it under the FEMA law, the income tax department would get to know it because of the inter-department treaty or the agreement that they have within the government.
Okay.
And then they would send out notices that this is undisclosed income. So now we are reassessing your income tax return for that particular year. Please show us cause. Why did you not report this income? If
Okay.
you've not shown cause, we'll raise a demand, a penalty, and a separate proceeding which is under the Criminal Procedure Code.
So it is a multi-pronged approach to counter black money or unaccounted wealth, as you say. So does the outcome, say in FEMA proceeding, would the outcome in FEMA proceeding affect the outcome of a IT Act proceeding or vice versa?
So as a practice, we professionals normally take defenses that such and such transaction had already received the approval of RBI. If it had received the approval of RBI, it's clothed with legality.
Okay.
So tax department can't really challenge that transaction.
Okay.
But there are judgments on both sides that mere legality under one law will not mean that that transaction is legal for all the laws or the purposes of all the laws. Because the remit of all the laws may be overlapping, but the parameters to judge the legality is different. So you may in one case of course rely on the legality under one law, but that is a questionable and rebuttable reliance.
So simultaneous proceedings but on independent footing,
Yes.
right? That's what it is.
Yes.
So let's come to the 2015 Act now, which is specifically called the Black Money Act. So before we talk about the kind of offences and crimes it underlines, can you just tell us what the law exactly is and why was a need felt to bring this law, particularly keeping in mind that we already have a package of laws, like we have Binami, we have FEMA, we have income tax. So why a special black money law?
So the answer to that question would lie actually in the longer name of the BEAR Act. Contrary to popular perception, Black Money Act does not address all the black money related problems. The name of the longer title of the BEAR Act is Black Money Undisclosed Foreign Income and Assets Act and Tax Act. So it's only and only related to something which is outside India.
Okay.
Foreign income and assets. So this was the need felt, and in the run-up to the 2014 elections also, one of the party's manifestos had said that they will bring back black money from outside of India.
Right.
And hence the need was felt to specifically address this issue, which will give a separate mechanism, machinery provisions for the tax department to exchange information with authorities outside India, have special levy of tax, penalty and prosecution proceedings specifically to people to identify whatever undisclosed income and assets are outside India. Before 2015 Act came into force, this was already being done by the Income Tax Act.
Okay.
So there was actually the coverage was already there, but the implementation was a problem.
And why do you say that it was a problem?
Yes, because as I've alluded to the fact before, till 2012 there was no need on an income tax assessee to disclose foreign assets. That was for the first time done in 2012. For the first time in 2015, in anticipation of the Black Money Act, another disclosure requirement was made that if you are not a direct owner but a beneficial owner, you please disclose it. So need was felt that instead of doing these constant amendments and running after or covering the ground after the deed has been committed, there has to be a proactive act
to prevent it.
to prevent this.
So it was introduced as a preventive legislation.
Yes, because the liabilities and the penalties in the Black Money Act are many times more than what are present in the Income Tax Act, and the consequences are also harsher than the Income Tax Act.
So what is the machinery that it actually puts in place to bring all of this black money back to the country?
Yes. So I'll start that with the basic structure of the Act.
Okay.
The basic structure of the Act, as I said, addresses foreign undisclosed income or assets. It is applicable only to the person who's a resident in India. It's not applicable to anyone who's a non-resident or has been outside India for many years.
Okay.
This is as far as the coverage and scope is concerned. Of course, there are definition provisions also, which define what is an asset,
Okay.
who is a resident, and who is a non-resident.
You just spoke about it doesn't apply to someone who's lived outside India for many years. So is that many years also defined?
Yes, the definition of resident or non-resident has reference to the Income Tax Act.
Okay.
Wherein-
Okay. So you go back to the Income Tax
Yes,
Act.
Section
Okay.
6 of the Income Tax Act, wherein there is a multifold criteria prescribed that you have to be in India for so many number of days or so many years in the past 4 years, then you will qualify to be a resident.
Okay. Okay. Got
So
it.
if you satisfy those conditions, then you are automatically a resident for the purposes of Black Money Act also. So this is as far as the scope and coverage is concerned. Thereafter comes the charge of tax. The charge of tax gives the rate of tax as well as prescribes the penalty. The rate of tax is flat 30% on the value of asset and the income which is undisclosed and found by the assessing officer.
Okay.
So far so good, but there is a mandatory penalty which is 300% of the value of
The
tax.
Or
of
the value of tax.
So,
Okay.
so this means that in total, if you let's say the value of the asset was 100, you are paying tax on that for 30 rupees, and there will be a penalty of 90 rupees, 30 into 3, 90. So you end up paying more than the value of asset itself. You end up paying 120 as tax and penalty for a value of asset which is 100, which is the current value, mind you. This was not present in the Income Tax Act.
Okay. So that's the difference.
Yes.
as
So
well.
it's much harsher. People would be then encouraged to disclose these assets well in time in their income tax return, pay 30% tax, and be done with it. Thereafter comes the assessment proceedings, where actually the investigation of the department starts. If you've not disclosed it, the department can, by way of exchange of information from other authorities inside India or outside India, collate information and issue show cause notices. And then the civil and criminal proceedings will follow.
So when we talk about department, is that the income tax department, or is it a special department created to?
So
Yeah,
under the
under
Black
this law.
Money Act, all the officers and the powers of the Income Tax Act are paramateria followed in the Black Money Act. So they are the same officers, they are the same department, of course with additional staff taking care of a special black money wing. But the powers and the structure of the department remains the same as the Income Tax Act.
Okay.
For all purposes, practical purposes, it is the Income Tax Act which is leading these proceedings, which is creating the charge, which is issuing show cause notices.
So when you read the two laws together, that is the Income Tax Act and the Black Money Act, can we say that now it is mandatory for the Indian residents, as per the law, to disclose any property or any maybe even a bank account if they have in any foreign jurisdiction? So does it make it mandatory for them now, or is it that if you do not disclose it, then you can face proceedings? So what exactly is it? What is the, I mean, can you just give a clarity on that point?
Yes. So under the Income Tax Act, it is mandatory upon them to disclose even a share that they hold in a foreign company.
Okay.
Let alone be a bank account, even an investment in a foreign company, they have to disclose under the Income Tax Act. If they fail to disclose that, consequences of non-disclosure in an income tax return will follow under the Income Tax Act.
Okay.
But the Income Tax Department will get to know that you've not disclosed it. This is a foreign asset. So the Income Tax Department will take out proceedings under this Black Money Act.
Okay, so it's like one follows the other.
Yes.
That's what it means,
Yes.
right? Okay. So, Deepak, just wanted to ask you another question is that, of course, we've had so many laws. So, how does black money really impact the country in terms of economy, governance? If you could just explain that as well.
So, as the concept of black money, it is not involved in the formal economy of the nation. It's all informal. If it is beyond the banking transaction and the banking route, neither the bank knows, nor the government knows, nor are you paying the taxes on that transaction to the government. And the GDP calculation is also affected to that extent. Because if it is informal economy, it doesn't go into the calculation of GDP numbers because they are not reported. So it's a deflated GDP to that extent. tax revenues, which are the major source of revenue for any government, get impacted, because of which the position of fiscal deficit, which we are very concerned about, also gets impacted. So this coverage actually increases the tax base, the tax revenue, which in turn helps the finance minister and the prime minister to really go about with their schemes, welfare schemes or other development capital asset generation schemes. So this is how the menace of black money affects governance and the economy of the nation.
Deepak, I remember there was this matter which was pending in the Supreme Court for a very long time, that was filed by our former law minister, Mr. Ram Jethmalani, where he had spoken about the problem of black money. And I think, if I remember it correctly, this law actually followed,
Yes.
Those long proceedings. But was this law framed under some international treaty, or was it just because of this particular case that this law was, brought into force? If I remember it correctly, it was because India was signatory to an international treaty to fight back the black money menace. Is that?
So there was not a case of an international treaty, but US has come up with its own law, which is abbreviated as FATCA, popularly known as FATCA law. So whatever transactions are being conducted with parties in US, the Indian counterpart and the Indian banking companies had to give out declarations to the United States of America that these are accounted for, these are disclosed, and the source of the money is also known to the Indian authorities. Probably that would have played a role. I am again saying that's not one of the major reasons why this act came into being, but that was one of the reasons.
Right.
The Supreme Court proceedings perhaps pushed the law to come into picture sooner than what it was anticipated.
Okay.
In fact, if you read the BEAR Act, the provision says that it will come into force from 1st April 2016, but it was already notified on 1st July 2015, which became grounds for several legal proceedings later on.
So now we've had this package of laws, and we've had the 2015 law. How has the implementation been on the ground? Are there any parameters on which this can be judged?
So when the implementation started, it was to start with something called as assessment year 2016-2017,
Right.
which would ordinarily mean financial year 2015-16 onwards. So they would test your income tax returns for that particular year. They had also given a one-time compliance window of around a couple of months from July to September, that if you have undisclosed income or asset, please be honest with us, disclose it within this act within before 30th September, and we'll waive off certain part of the penalty. So that would convert your black money to a regulated white money kind of situation. That was the first step in the implementation. The second step in the implementation would have ordinarily started, but for several High Court writ petitions which challenged the retrospective applicability of the law.
Okay.
One problem was, as the act was to be scheduled to come into force from 1st April 2016,
so they
had preponed the implementation to 1st July 2015. That was challenged in the Delhi High Court, in the Bombay High Court, and several other high courts also. This finally got decided by the Supreme Court in the Gautam Khaitan case, which arose from the Delhi High Court proceedings. And the Supreme Court said that this is not actually a retrospective applicability. They are notifying the amendment to the act that certain provisions require implementation as on today. You can't wait till 1st April 2016.
Yeah.
So that was the first roadblock. That decision got pronounced only in 2019 or some.
Okay.
After that, there was another roadblock. Assessments started happening. Notices were issued to several big names in the industry. All of them rushed to the High Court on one ground. The Act has a very, very minute differentiation on the treatment of foreign income and foreign asset.
Okay.
As far as foreign income is concerned, it's very clear it applies prospectively from assessment year 16-17, as I've explained. But what to do about the asset? There may be cases where the person concerned is still holding the assets. That's case one. Case two would be he might have held the asset back in the time but also disposed of the asset. That's case 2. Now the department is covering even case 2 under this act,
Okay.
which the parties are saying goes contrary to Article 20 of the Constitution also, because
Right.
it wasn't a crime back then.
But then, that's right, yeah.
And also the retrospectivity of the act to that extent,
Okay.
which gets saved by the wordings of the act. So that matter is still pending before the Bombay High Court and the Delhi High Court.
Okay.
It's still pending.
Okay.
And stays interim order have been granted.
So we
Stay.
still have to see how those provisions
Yes.
will be
Or,
implemented.
or in fact, see how effective the law
Yes.
is.
Exactly.
Because of these roadblocks, it is,
Yes.
I mean, the government may not be
In
in a
fact,
position to.
this is a very nascent and fresh law in that sense.
Right. Right.
Several other problems apart from the retrospectivity is also coming to light.
Yeah.
For example, many terms have not been defined in the act.
What terms are these?
So there is no definition clause for financial interest. Asset
Okay.
includes a financial interest, but
Oh.
what is a financial interest? No
Okay.
one knows. Whether your participation in a discretionary offshore trust would mean that you have a financial interest. There is a contrary ruling by the Income Tax Appellate Tribunal, one in the favor of the assessee, one against the assessee, under the
Okay.
Black Money Act itself.
Hmm.
The other part is that what will happen to those people who were residents when the foreign assets were acquired, but now the status is of non-resident. Because the applicability, as I have told you, is only on the
Right.
residents.
On the residents, not on the non-residents.
So, in
okay.
2019, the government realized that this may be a loophole. They've amended the law retrospectively from 2015,
I see.
stating that if a person was resident at the time of acquisition of the asset, but is no longer a resident, even that person will be covered within the Black Money Act.
Right.
So these are challenges which are arising, and I'm sure these will travel to the court also, as the other challenges have traveled.
So now, since you mentioned that the other package of laws also was sort of playing catch up with everything that was coming up, do you think this law might meet a similar fate with all these challenges coming up?
It might, more so in the light of the Binami Property Act
Judgment by the
of
Supreme
the Supreme
yeah.
Court.
Right.
Yeah.
Because the theme of that judgment is that when you are making such substantial changes for the first time, and also including a new category of taxpayers, you can't really have retrospective effects, and you ought to have certain safeguard and guidelines in place.
Yeah, okay.
Right.
Both these factors are missing in the Black Money Act.
Right.
So whenever the matter travels to the highest court of the land,
This
this
will
will have
definitely come up.
some bearing on it.
So that we'll still have to
Yes.
see. Okay. On that note, we've reached the end of this episode. In this episode, we spoke about the package of laws that have and continue to deal with black money in the country, and we also spoke about a new law, which is the 2015 law dealing with undisclosed foreign income and assets. The implementation and effectiveness of this law is yet to be judged though, and we'll just have to see how courts rule on it, and whether this law also maybe ends up playing catch up with all the challenges that have been posed and all the undefined terms that Deepak spoke about. Thank you so much for joining us, Deepak.
Thanks for having me.
And thank you so much for watching this episode. Do let us know what you think about this show and this episode, and do subscribe to our YouTube channel and follow us on Twitter and Instagram.